Hello, this is Matt on the Moon Lambeau channel. The SEC, in a new legal brief, has indicated their intent to appeal the SEC v. Ripple lawsuit in some capacity, but they're being intentionally cryptic. I'll show you exactly what I mean. And then there's a bigger question. Even though this is what they're asserting in this latest legal brief, and by the way, it's a legal brief in a case that isn't the SEC v. Ripple case, of course. Even though they're asserting this, the question is, are they just bluffing because they're a bunch of baby back biatchas? Probably. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so I've got perspective from several attorneys within the XRP community. That'll include Attorney John Deaton, Attorney Jeremy Hogan, Attorney Bill Morgan, and Attorney Fred Rispoli. Also, shout out and credit to Attorney James K. Filan for sharing some news on this story. He shared this Wall Street Journal article, and it's not the one that I pulled up right now. It's behind a paywall, and actually I do have a subscription. I just didn't feel like getting my login credentials. But so here's a similar headline from Bloomberg: SEC signals appeal to crypto Ripple ruling in response to Terra case. And what's being referenced here is the remember the Terra Luna fiasco from May of last year that caused the downward spiral for the rest of 2022, culminating in the collapse of FTX, which we found out was an outright Ponzi scheme. That was a good time. Oh, how I missed 2022. What a glorious time to be in crypto. Yeah, so that's what set it off. And then the snowball effect, I'm sure you'll recall, I don't even need to tell you guys, right? With Voyager and Celsius and all that stuff, all these collapses and then the BlockFi implosion, all that crap. Well, the co-founder of Luna, his name is Do Kwon, and he was seeking to have, as a result of this, the conclusion of the SEC v. Ripple case, seeking to have his case thrown out because the SEC is coming after him as well. And so what happened here in this latest SEC legal brief that they filed, they're pushing back and saying, no, of course this shouldn't be thrown out, but they talked about the Ripple case. And so here Attorney Filan tweeted out the following. He wrote, XRP Community. In the SEC v. Terraform Labs / Do Kwon case, the SEC has filed a pleading discussing Judge Torres' decision in SEC v. Ripple, in which it states that, quote, SEC staff is considering the various available avenues for further review and intends to recommend that the SEC seek such review. And I'm actually going to pull up the actual brief in just a moment here. But first, let me touch on just the top part here for a minimal amount of table setting. This is from the Bloomberg piece. The U.S. Securities and Exchange Commission asked a federal judge to ignore parts of a recent ruling in the regulator's litigation with Ripple Labs, Inc., saying the decision doesn't square with existing securities laws and that it may appeal. The ruling in the Ripple case concluded that sales of Ripple's XRP token directly to institutional investors violated the SEC's rules, but offerings to retail investors on exchanges didn't, delivering what was widely seen as a victory to the crypto industry. Spot on. And no matter how much the SEC wants to try and spend it, it was a massive loss for them. The first loss in a crypto case for the SEC, and it came at the most crucial moment that it possibly could have. And so here's page 1 of 6 in this brief from the SEC, and this is the part that I want you to see right here. And it's in part hilarious to me, and I'll explain why in just a sec, but it reads as follows. Contrary to defendants' assertions, much of the Ripple ruling supports the SEC's claims in this case and rejects arguments defendants have raised here. However, with respect to programmatic and other sales, the SEC respectfully avers that Ripple conflicts with and adds baseless requirements to Howey and its progeny. So let's get a pause and say, that is rich. Ripple conflicts and adds baseless requirements to Howey? You little pricks. You know, do you remember this too? The SEC, they outright stated, and I didn't pull it up for the purposes of this video, just popped in my head, but I have shared the actual specifics on at least a couple occasions on my channel. The SEC outright stated that as it pertains to the Howey test, you know, the ruling, which, mind you, this came from the Supreme Court in 1946. Part of that was that there has to be a common enterprise. And the SEC in a footnote somewhere they wrote, they recognize that the courts require that there be a common enterprise, and I'm paraphrasing here, but the SEC said that they don't require it. That's a jaw-dropping thing. Whoa, you're literally saying the courts require it, but we, the SEC, we don't require it. What? And then you have the audacity to come out and say Ripple is making a basis of requirements to Howey? And it's the most ridiculous. If you've been following this case, and if you read the ruling or heard anybody break it down, the relevant portions, you know that Judge Torres simply applied the law, applied the Howey factors, and XRP as it pertains to programmatic sales, not illegal securities transactions. Anyway, and then the little asshats at the SEC wrote, quote, respectfully, those portions of Ripple were wrongly decided, and this court should not follow them. SEC staff is considering the various available avenues for further review and intends to recommend that the SEC seek such review. Now, that's hilarious. So first of all, there's outright saying Judge Torres wrongly decided this. Okay, well, you're wrong. You never had you were never on the right side of history. You never had proper legal arguments. You were making stuff, pulling it up out the rear side, the embodiment theory, all this and that. No. But the last sentence is what cracked me up. Because, and again, it reads as follows. SEC staff is considering the various available avenues for further review and intends to recommend that the SEC seek such review. What in the ever-loving hell? Do you understand what they're saying here? The SEC intends to recommend to itself that it do something. What the hell is wrong with these pricks? What is wrong with these idiots? Did you ever speak like that about yourself? I intend to recommend to myself that I go eat a pizza. Like, does anyone talk like this? We're the SEC and we intend to recommend to ourselves. Blah, 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 blah. So obviously what they're hinting at here is appeal without saying appeal. Everybody gets that. And so we're going to go a little bit further, and actually, Attorney Hogan did a good job addressing this, because we get to the heart of, like, is this something for real that they're going to do, or is it just a bluff? Now, I had brought up, even before we had the ruling from Judge Torres in this case, I warned that it's possible that the SEC could file an appeal, even if we get good news as XRP holders, and it could be used as a bluff. So that's already something that I talked about on this channel. It could be part of the SEC's strategy, but they're still coming from a position of weakness if so. Now here's what Attorney John Deaton had to say. He said, read footnote 13, people, and it's, quote, the court holds only that a common enterprise existed between Ripple and the institutional buyers. The court does not reach the question of whether the common enterprise extends to encompass other XRP holders, defendants Garlinghouse and Larson, the XRP ecosystem, or any other entities, end quote. And then Attorney Deaton says, the common enterprise factor is even more difficult for the SEC to meet than the third factor of the Howey test. Even if the SEC was successful appealing Judge Torres' ruling, all that happens is a remand, and Judge Torres will likely decide the SEC failed to prove the common enterprise factor between Ripple and XRP holders in the secondary market. Yeah, and I'll pause to note, that shouldn't be surprising should that occur, because there's literally, and Attorney Deaton submitted this, thousands of sworn affidavits from XRP holders on why they purchase XRP, and the data shows that over half of first-time XRP purchasers didn't even know that Ripple existed. Them's the facts, son. And you're going to tell me that they're somehow magically in a common enterprise when most people don't, when they first buy XRP, that they're not even aware of Ripple? Yeah, good luck with that one. And then Attorney Deaton says, remember, the SEC flip-flopped its common enterprise theory 3 times, finally arguing that XRP itself represented the common enterprise. Let's pause a note. That's the embodiment theory right there. And then Attorney Deaton wraps up the tweet by stating, I think it's time people start accepting that the SEC's theory in this case was circular and conclusory, and that's why it lost. Golf clap for Attorney Deaton, everybody. Spot on. And then in this tweet, he shared something from somebody named Dave Michaels, who works at the Wall Street Journal. Dave Michaels wrote, SEC files response in Do Kwon lawsuit saying Judge Annalisa Torres erred in her XRP ruling and the agency is likely to appeal. The kicker, quote, Ripple's reasoning is impossible to reconcile with all these fundamental securities laws principles, end quote. Which is laughable. And Attorney Deaton points out a good reason why. John Deaton wrote, until the SEC can cite a single case where the Supreme Court added a Howey factor requiring the judge to consider the level of sophistication of the investors entering into the common enterprise with the issuer/seller, or a factor that requires the result after the Howey application to be consistent with policy considerations behind the 1934 Securities Act, the SEC lawyers sound just like the prima donna crybabies they are. Get another golf club, Attorney Deaton. Hit the nail on the head. Absolutely. And actually, Paul Gray, and this is actually funny timing. I'll just assume that Coinbase's chief legal officer, Paul Graywall, wasn't copying John Deaton, because John Deaton tweeted that out at 7:14. 9 minutes later, 7:23 p.m. Central Standard Time, Paul Graywall also retweeted Dave Michaels, and he shared the same message. He wrote, quote, if only the commission cited one case, any case, in which the level of howiness required varies based on the sophistication of the investors at issue. Tellingly, they don't. And once more argue policy over the law as it is. So that's very samey. So apparently they came to the exact same conclusion inside of 10 minutes of one another. John Deaton was first, of course. Now, also interestingly, Mark Cuban of Shark Tank fame responded to Paul Graywall and wrote the following. They also refer to every buyer as an investor in their filing. That's not the case, and Ripple made that clear. Securities have one purpose, to be a security. For a DeFi or centralized exchange buyer, it's impossible to know why a buyer buys. But it is possible to look at the blockchain and see there are transactions based on the utility of the token. Right. And then Paul Graywall responded and said, yes, hammers only see nails. Exactly. That's spot on. And so the SEC doesn't know why anyone's buying anything. They can't get in the hearts and minds of the purchasers, obviously, nor have they even tried to. But they're asserting that every buyer is a quote-unquote investor. Well, you saw what happened in the SEC v. Ripple case. And so I retweeted Attorney Filan, and I wrote the following. I found Attorney Jeremy Hogan's rationale as to why the SEC likely wouldn't appeal Judge Torres' SEC/Ripple decision to be highly persuasive. If the SEC ends up appealing, as it now seems they will, it means we underestimated the recklessness and arrogance of this disgusting agency. Now, just pause to note here, given that this is Twitter, I can't fully flesh out thoughts, which is why I much prefer sharing my thoughts on YouTube, where I can use my mouth words. That's much easier. So it's not just... So, okay, here's what I wanted to break down. If the SEC is actually not just going to appeal, but they really mean it, and it's not a bluff, and they're really going for this thing, then yes, that's extreme recklessness and arrogance, because if this gets upheld by a higher level court, it becomes binding precedent and wrecks the rest of the lawsuits that they're going after. Do they want to risk that? And so Attorney Hogan's position for a long time has been, no, he doesn't think that they're going to do that. But I've brought it up many times before, even before the end of the SEC v. Ripple case, I warned, hey, they could use it as a bargaining chip. You know, they could put forth, hey, we want to appeal, or hint at it. They could do either of those things. But even if they do go forward with the appeal, doesn't mean that it's going to see a conclusion. You know, it could be used as a bargaining chip with Ripple. So even if they go forward with that, it could simply just be that. Now, Attorney Bill Morgan responded to me and he said, I said they would appeal. Yeah, and if they do, I'll just say credit to you, Attorney Bill Morgan, because he has been saying that, and that is the majority opinion. And so I don't pretend to know. I respect and appreciate the perspective from all the attorneys that are sharing what they think is most probable here, and their train of thought and all this stuff. And maybe Bill Morgan was right from the beginning. And so my perspective, just as somebody who's not an attorney, just as a lay person hearing the arguments in terms of if I'm at the SEC, what do I think is the best strategy? I would say to not appeal. But again, if they're going to be reckless idiots, then okay. And so I responded to Attorney Morgan and said, yeah, I think most lawyers have held that opinion. I think Hogan's perspective makes logical sense, but the SEC isn't making logical or reasonable moves, or even moves in their best interest. Okay, now I couldn't more fervently believe that. even the fact that the SEC, and I know this was under Clayton at the time, under SEC Chair Jay Clayton, the fact that they even brought this suit against Ripple was an idiotic move. Not only because they're on the wrong side of history and the facts don't match up with what they were asserting. On top of that, they're making up bogus nonsense theories. So the law wasn't on their side anyway. But so not only was it stupid for that reason, but Ripple had a veritable war chest. I mean, it wasn't long ago that Brad Garlinghouse noted that they had over $1 billion in the bank. So if that's the case, do you think they're going to back down? Do you think they might get some incredible lawyers who used to work at the SEC and push back against you? Because that's what they did, with one of them being a former SEC chair. So it was basically like former SEC employees and executives, litigating against the current SEC. It kind of was that, except for one of them had the law on their side. So that was a boneheaded move. They should have engaged in better strategery and gone after some low-hanging fruit and got some wins, tried to set some precedent, and then go after some bigger ones, and then you can point to those cases. But they went right for the jugular and going after Ripple. Not straight away. They went after, there was the Kick Interactive case, there was Telegram. I know there were a few others. But to so quickly go to something like a Ripple, what a bunch of dumbasses. That didn't work out for them, did it? It's like, well, things really escalated quickly there. So somebody asked Attorney Rispoli and tagged Attorney Deaton and Hogan, what do you guys think about this? And Attorney Rispoli responded and said, I want to say who cares, but that's too flippant. SEC can appeal, but even under the fastest timeline, which is the least likely of appellate options, it won't get a ruling until 2025. Ripple is in the driver's seat now. And praise the Jesus for that. And then in a separate tweet, he shared a quote from this brief. SEC staff is considering the various available avenues for further review. And then he wrote, translation, we really took it hard in the you-know-what, Your Honor, in that Ripple case, but we are going to appeal and win. And when that happens in 2 to 3 years, we'll be back letting you know. We'll let you know so hard, in 2 to 3 years, Your Honor's head will spin. I thought that was good. So might they be bluffing? Might they be bluffing? Well, here's what Attorney Hogan had to say about this. He retweeted the news from Attorney Filan, and Attorney Hogan wrote, heading into a settlement conference, an appeal is really the only ammunition the SEC has against Ripple. Of course, it says it will appeal. I don't think you can read too much into that statement one way or another. And it's fair enough. So there you go. So he's thinking that there's a pretty reasonable chance that this is a big nothing and it's just a show of force. So it's the SEC huffing and puffing, but there's nothing actually there. Which is totally plausible. So Attorney Hogan still could be right that the SEC ultimately is going to want to wrap this thing up rather than appeal. And then somebody named BJ Hodges responded to Attorney Hogan and said they also have to say that to continue to justify their other cases, both current and coming. Yeah, and that's a pretty good point too. As Attorney Hogan wrote, yes, that also good point. Because if they see too much ground in the SEC v. Ripple case, what's that mean for the other endless number of SEC lawsuits attacking all of crypto, including the cryptocurrency exchanges out there? Because a big assertion that they made, like in the Coinbase case, is they named however many cryptocurrencies and said that those are actual securities without actually charging the parties involved with developing on them or selling them or anything of the sort. So they just leave Coinbase to have to defend, on behalf of whether it's a dozen developers. I can't remember how many coins it was. There's a lot of them. So now if you're Coinbase, though, if the SEC ends up giving up on this, well, that makes life a lot easier. So not that they're going to give up on it, but the point is they need to maintain the image, the optics. So I think that was a really good point from BJ Hodges, and Attorney Hogan agreed. And then there was this tweet from XRP community member Yasin Mubarak, who wrote, this is simply posturing by the SEC to get ready for negotiation with Ripple. When you are in a weak position, you have to bluff to appear to have leverage. But the reality is, as Attorney Rispoli said, Ripple is in the driver's seat and everyone knows it. And Attorney Hogan responded and wrote, spot on. And I agree as well. So it's just, this is a complete and utter disaster for the SEC. And they put themselves in this position. I have no sympathy. They are absolute devils as far as I'm concerned. They have wrecked people's lives. And just, like, seriously, the financial destruction that they caused, I mean, they ruined people. There are people, and understandably so, who panic sold as the price was going down and just ruined people. You know, because again, that's not something that happened because of open markets or even because of Ripple. It's because of a bogus assertion the SEC made, and then understandably people responded and thought, oh gosh, could this be the end? And then there's not clarity on what this means. It's not just a regular, oh, this thing's going down because there's volatility in crypto. It's to some people it looked like doomsday, like it was the end of the world. And it's disgusting. So I mean, I have no sympathy for them whatsoever. They're just absolutely awful. It's just unforgivable what they've done. But they lost. Oh, bitches. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.